Hi everyone. So today's topic for discussion being basics of shareholders agreement. Let us first understand what is a shareholders agreement. Now, sometimes certain persons, including friends, come together to carry out a business or form a company. At times, an existing business requires funds and money is infused by investors. These persons or investors, as the case may be, would like to protect their interest in the company, and that's where a shareholders agreement comes in handy. So what is a shareholders agreement? A shareholders agreement is a contract between all or some of the shareholders of a company by which they agree and govern how the company is run. By way of a shareholders agreement, the parties decide the course of procedure they will follow with respect to their rights, dividends, and obligations, and if certain events were to occur, such as a dispute or deadlock. It also allows to document an exit strategy for some or all of these shareholders. Now, a shareholders agreement should always be read and reviewed in conjunction with the company's articles of association. The articles of association, as we know, is one of the charter document or constitutional documents of the company. The articles of association contain various important provisions concerning the internal regulation of a company. Hence, certain provisions of the shareholders agreement are entrenched into the articles of association for the purpose of enforceability. These would mainly be restrictions on transfer rights, exit rights, board and management rights, or reserved matters. Now, for the purpose of this presentation, I will cover some main components or clauses that you will typically observe in a shareholders agreement, and my co-panelist Harini will explain how some of these terms have been dealt with by the courts. Now let's see what a basic shareholders agreement would cover and the ingredients and components of a shareholders agreement. So we start with the name clause. This will cover the names and information of the parties. We move on to recitals. This will give a brief insight into the background as to why the shareholders agreement is being entered into. At times, the parties have already entered into a share purchase agreement or a share subscription agreement. And to protect their interest in pursuance of entering such a share purchase agreement or share subscription agreement, the parties enter into a shareholders agreement. Moving on, we have definitions and interpretation. This section will define and interpret the terms used in the rest of the shareholders agreement. You will also see an effective date clause. Now, this clause will cover as to when the parties desire the shareholders agreement to be effective from. Now, in certain shareholders agreement, you won't find this as a clause, but it will be defined in the start of the shareholders agreement itself. Moving on, you have the capital structure clause. Now, this clause will cover the shareholding pattern of the company on a fully diluted basis. So what do you mean by when you say fully diluted basis? So it essentially conveys that the equity of the company is to be calculated, assuming that all convertible instruments have been converted into equity. This gives a party a precise picture of how much equity percentage it will eventually hold in the company. Now, at times, this clause may also cover that when a shareholder investor is injecting money into the company, they also require that it be provided as to how the proceeds of the investment amount be utilized for certain purposes, such as a business plan. And if required for any other purpose, then the amount cannot be used without the prior written consent of the investor shareholder. The next clause that you would see is the preemptive rights clause. Now, preemptive rights are those rights which ensure that a shareholder's ownership interest is not diluted due to issuance of additional shares. A preemptive right allows the existing shareholder to maintain his proportion of ownership in the company by allowing him to acquire proportional shares in any additional share issuance. For example, a shareholder has 100 shares in a company, which currently has 500 shares outstanding. At this point, the shareholder owns, say, 20% of the business. The company wants to sell another 500 shares in order to raise funds. If the shareholder wants to maintain the same proportional ownership of the business, it must buy 100 of these additional shares. However, the existence of a preemptive right does not mean that an existing shareholder has to purchase additional shares. The shareholder can choose not to exercise the right, in which case shares are sold to other parties and the existing shareholders' ownership proportion in the company will automatically reduce. The next clause that you will usually see is restriction on transfer of shares. This clause covers the restriction on transfer of shares by the parties. You will usually see under this clause the terms such as promoter lock-in, right of first offer, or a right of first refusal, tag right. Restriction on transfer clause can be split into promoter transfer restrictions or investor transfer restrictions as well. In the clause of restriction of transfer of shares by promoter, the promoters of the company undertake that they will not transfer or part with any portion of their shareholding in the company to any person, which includes a competitor as well, without the prior written consent of the investor or the other shareholder. Usually, such a lock-in period is provided till the investor or the other shareholder holds shares in the company. But permitted transfers are allowed, whereby the promoter can transfer its shares for wealth management purpose or to its lineal descendants. Usually, such permitted transfers are capped at a percentage as well, that is, say, not more than 10% of the promoter shareholding. Also, under transfer restriction clauses, you will come across the following terms such as right of first refusal, right of first offer, tag right. Now, a right of first refusal, also known as ROFR, the seller is first required to offer his shares to third parties and obtain a price for them for this. The seller is then required to approach the right of first refusal holder with the price offered by the third parties. If the right of first refusal holder can match or better the price offered by the third parties, the seller must sell his shares to the right of first refusal holder. Now, in the right of first offer, or also what we call as ROFO, subject to the terms of the contract, the seller is obliged to give the holder of the ROFO the first chance to buy the shares. The ROFO right holder has a specific time period in which it will have to make the offer. The seller is at a liberty to either accept or reject the offer. If the seller rejects the offer, then it can sell it to a third party without any restrictions, but not at a price lower than what was offered by the right of first offer holder. So generally, there is the time period which is also provided within which the seller can sell it to the third party. If the seller is unsuccessful to obtain a price from the third party within the time period, then the seller has to approach the right of first offer holder again. At that point, the ROFO right holder is not obliged by its original offer and can even lower it. Now, therefore, for an investor seeking to exit a company, the investor will prefer that the promoters have a ROFO, that is a right of first offer. Why would that be? Because the ROFO provides the investor a price with which to begin negotiations with third parties. And the process of price discovery remains in the hands of the investor. But if there is a right of first refusal in favor of the promoters, a third party would be reluctant to buy the seller or the investor shares, as even after a due diligence, which does involve time and cost of the third party, to discover the price for the investor shares, there is a possibility that if the promoter provides a better price than the third party, then no sale would occur in favor of the third party. Therefore, promoters usually strive and negotiate for a right of first refusal, as it gives them the leverage to buy the investor shares by only matching or by slightly enhancing the price. Hence, this is a point one has to be mindful of when drafting a shareholders agreement. The other term that you will come across is a tag right. Now, a tag right is useful as sometimes investments are made based on the capability of the existing promoters or shareholders. Thus, a tag right is used by an investor or the other shareholder when the promoters or an existing shareholder, as the case may be, decide to sell their shares, in which case the other shareholder or the investor can sell its shares on terms similar to those offered to the promoters or the existing shareholder. The tag right provides an exit opportunity to the investor or the minority shareholder if the existing promoter or majority shareholder, which is being the reason for investment, are exiting the company. So restriction on transferability of shares is one of the core attributes of a private company. This has also been codified statutorily under the definition of a private company under subsection 68 of section 2 of the Companies Act 2013, which provides that a private company means the company which by way of its articles restricts the right to transfer its shares. Whereas in case of public companies, the shares are freely transferable. Whether transfer restrictions imposed contractually on shares of a public listed company are enforceable has been a contentious question now. There have been various decisions of the Supreme Court and High Courts with differing views. However, if you see the decision of the Bombay High Court in Messer Holdings versus Shyam Madmohan Ruya and others, it ruled that the restrictions in an agreement between shareholders do not violate the Companies Act and that they can be enforced inter se among shareholders. Now, this decision deviated from the ruling of the Bajaj Auto Limited case, wherein a preemption clause was held to be in violation of Section 111A of the Companies Act 1956. However, this has now been statutorily codified and provided in the proviso to subsection 2 of Section 58 of the Companies Act 2013, which provides that any contract or arrangement between two or more persons in respect of transfer of securities shall be enforceable as a contract. I will now hand over to my co-panelist Harini to take us through some of these cases and positions held by the courts.
Thank you, Khush. Before I share with you more on the judgments, I'd like to share with you all a quote that I'm drawn to. And I think many of you will agree when I say that there is no better way to exercise your imagination than the study of law. No artist can interpret nature as freely as a lawyer can interpret a contract. So with this, I hope our session will also aid you in your drafting and interpretations. So let me now move back to the topic that Khusnuma was addressing. So one of the landmark judgments that set the tone for enshrining the clauses of the shareholders' agreement in the Articles of Association is the Supreme Court matter in VB Rangaraj versus VB Gopalkrishnan. And this was heard by the Supreme Court in the year 1991, and this concerned a private limited company. The main question before the Supreme Court was this: whether the shareholders can, amongst themselves, enter into an agreement which is contrary or inconsistent with the Articles of Association of the company. So the case facts are this: there were two brothers, shareholders of a private limited company, and each of these brothers had sons. So when the brothers died, the sons obtained the shareholding in the private limited company. And there was an oral agreement between the families, and this was not enshrined in the Articles of Association, that the shareholding would remain equal between the family trees with a ROFO option attached to that family. So if an individual were to sell, his brothers would get the first option before the other family tree. But one of the sons of the brothers, let's call him A for this purpose, he unilaterally sold his shares to the sons of the other brother. So A's brothers obviously filed a suit to declare this transaction void. And this was because there was an oral understanding which stemmed from that earlier arrangement between the families. So the trial court and the high court decreed in favor of A's brothers, and they held the sale to be invalid. But when this matter was taken up before the Supreme Court, the argument that was put forth by A's cousin's lawyers was that since the agreement was not enshrined in the Articles of Association, the restriction was not binding on the shareholders. So it was unenforceable and therefore not binding on the company either. So the Supreme Court here examined the Articles of Association, which I'd like to share with you. The Articles of Association said, on the death of any member, his heir or heirs or nominee shall be admitted as a member. And if such heir, heirs or nominee is or are unwilling to become a member, such share capital shall be distributed at par among the members equally or transferred to any new member with the consent of the majority of the members. So in this case, the private agreement that A's brothers had relied upon, it was not contemplated in the Articles of Association. So you can clearly tell that the articles didn't restrict the transfer to only one branch of the family. So the principle that was established by the Supreme Court was that the agreement imposing a restriction contrary to the provisions of the articles would not be binding on the shareholders and the company. Now, vis-a-vis this, for public limited companies, there were two landmark judgments. So one is the High Court, Bombay High Court ruling in the case of Bajaj Auto Limited versus Western Maharashtra Development Corporation in February 2010. And the other judgment, which was just 7 months after the pronouncement in Bajaj Auto by the same court, was in Messer Holdings Limited versus Shyam Madan Mohan Ruya later that year. So in this first case, Western Maharashtra had purchased shares in Maharashtra Scooters Limited, a public limited company, from Bajaj Auto, and the parties had entered into one agreement. Now, as per this agreement, if either party intended to part with their shareholding, then this party was required to give to that other party the first option to purchase the shares at a mutually agreed price or a price that could have been determined by an arbitrator. And these rights were also captured in the Articles of Association of the company. So what happened? The main bone of contention was with the price, of course, at which these shares could be sold, and so this matter went into arbitration. Bajaj Auto at the arbitration contended that this agreement with this particular clause that gave the ROFO was actually in violation of Section 111A of the Companies Act 1956. For your benefit, on the screen you would see the operative portion of the section. So if you look at subsection 2, that says, subject to the provisions of this section, the shares or debentures and any interest therein of a company shall be freely transferable. So obviously the arbitrator rejected the contention, saying that the agreement was a private agreement only binding the two shareholders, but Section 111A did not prohibit these shareholders from entering into private arrangements, such as this agreement regarding specific shares. So the preemptive rights under that agreement were valid and therefore binding on the parties. But when it went to the Bombay High Court set aside the award of the arbitral tribunal, since Section 111A very clearly talks of free transferability, and therefore any transfer restriction would be patently illegal. And then 7 months later, you have the judgment of Messer Holdings Limited versus Shyam Madan Mohan Ruya. And here, just to briefly touch upon the facts. So there was this German company which was in the business of supplying industrial gases, Messer Grisham GmbH. Now this company acquired over 50% in a listed company called Bombay Oxygen Corporation Limited. There was a share purchase agreement to this effect between just the majority shareholders. Now, one of the clauses of the SPA also contained a right of first refusal. So, Messer attempted to transfer its stake in Bombay Oxygen to Messer Holdings Limited, which was a joint venture which this German company formed along with another partner, which incidentally was a competitor of Bombay Oxygen. Obviously, this was an issue, and the Bombay High Court had to decide on whether this transfer was enforceable. So the Bombay High Court held that shareholders are free to enter into consensual agreements amongst themselves insofar as they do not conflict with the articles of association of a public limited company. Just wanted to add here that this matter did go up to the Supreme Court in 2016, 6 years after the judgment was pronounced by the Bombay High Court. But for some reason, the Supreme Court refused to take up this matter. And we feel that this issue surrounding enforceability remains contentious, but the Supreme Court could have clarified and addressed this conflict possibly. Khusnuma, over to you to discuss the next aspects.
Thanks, Harini. So the next clause that you would usually see in a shareholders agreement is board management and related rights. In this, shareholders agreement will typically cover board composition and management structure of the company. This usually includes appointment of directors, your composition of the board, quorum requirement, meetings and notice requirements, and reserved matters as well. Now, what do you mean by reserved matters? So reserved matters are a list of activities on which decisions or resolutions cannot be made or passed without the consent of the investor or such shareholder that holds such a right. Now, there can be a laundry list of reserved matters, but just to name a few, it would include change to share capital, amendment to articles, any change of business of company, appointment or change of auditor, dissolution or winding up of the company, or any merger, demerger, or acquisition. Now, decision making can pose its own challenges, especially on matters which require unanimous consent. So in such situations where the decision remains unresolved on a particular matter or activity, a deadlock occurs, which is unsettling to the running of the business, brings a standstill to the decision-making process, and diminishes the value as well. A deadlock can now occur both at a board meeting or a shareholder meeting. Hence, you will see that a shareholders agreement also provides deadlock resolution mechanism, where in case of a deadlock, the matter is escalated to the designated representatives of the disputing parties or the joint venture partners, as the case may be. When the deadlock cannot be resolved through amicable consultation, then a mechanism is laid down for an exit whereby one party buys out the shares of the other. It is in the best interest of the parties that a deadlock situation be avoided and be settled amicably by parties through senior level mediation. Also, it is important to note that a deadlock by itself does not mean that there is a dispute per se, as there is no breach of a covenant or a representation or warranty which is occurring, which are usually resolved through your dispute resolution clause in a shareholders agreement. So even an arbitrator who has the power to resolve such a dispute in a shareholders agreement may not have the power to resolve a deadlock in the absence of a deadlock mechanism in a shareholders agreement. And one may not want to tread on that path of having a deadlock resolved by an arbitrator. On this note, Harini, do you have any interesting live case to share on this point?
Yeah, so I think all of you would have come across the Tata Cyrus Mistry battle that has been going on for many months now. There are many facets to this case, but we thought it would be good to get a flavor of how skewed the provisions of the Articles of Association can be. So as you all know, just to give you a brief background, the Shapoorji Pallonji Group held around 18% of share capital in Tata Sons Limited, and Cyrus Mistry was appointed as the chairman after a rigorous selection process. So obviously it was surprising when he was removed as the chairman for lack of performance, and he later stepped down as director voluntarily. But here I'd like to just focus on Article 121 and Article 121A of the Articles of Association of Tata Sons Limited, which were introduced in 2000 and 2014. This provided a veto on every decision that was to be taken by the board of directors of Tata Sons Limited to nominee directors appointed by the trust. So obviously the decisions were going to be skewed in favor of how the trust wanted them to go. And this was also observed by NCLAT. So the NCLAT actually said that the articles have an overriding effect and rendered the majority decision effectively subservient to the trustees, effectively making the position, of a chairman toothless. So we wanted to bring up this case only to show the degree of skewness in an articles of association and its interpretation. Khusnuma, over to you to move ahead.
Thanks for that interesting case, Harini. So the next clause that you would also come across in a shareholders agreement is on information and inspection rights. Now, in this clause, the investor requires the company to share with it certain information such as audited financial statements, annual business plan, quarterly management reports, certified copies of board minutes, monthly management information statements. It will also provide that any party on informing the company in advance can be entitled to inspect the facilities or the books and records of the company, and also to discuss the business, operations, and conditions of the company with its directors or accountants and legal counsel. Moving on to the next clause. The next clause that you would see in a shareholders agreement is an exit clause. Now, this is also a very important clause to note because this clause provides an exit opportunity to the investor or shareholder by means of either a qualified IPO, or if that does not happen within the specified timeline, then by strategic sale or third-party sale, or by buyback of the promoters, or a put option, or a drag-along right. So what is a drag-along right? Let's look at that. In case of a drag-along right, the investor or the shareholder which holds the drag-along right can drag the promoter to sell its shares as well in case of a third-party sale. So sometimes the third party which is acquiring the company from an investor may not want a shareholder remaining with a minor stake in the company. At that time, a drag-along right comes to use as it allows the drag right holder who is desirous of selling its shares to the drag and it will allow it to drag the minority shareholder in selling the shares of the company to this third party. Now we keep seeing these exit provisions in our shareholders agreement. So they are well placed in theory, but in practicality, how much of it actually works? Many a times it is not the right timing due to external market factors for the promoter to go ahead with the qualified IPO, and the investor will not get the desired return on the investment they are looking. Strategic sale or third-party sale also, one has to scout for buyers, and sometimes it is difficult to get buyers. In case of buyback by promoters, the promoters at times do not have the financial standing to buy back the shares. So therefore, while a shareholders agreement does provide for exit clauses, how much of it can be implemented does remain a challenge most times. The next terminology that you will see are call and put options. Now, call and put options are also frequently used in shareholders agreement. A call option means the holder of the call option calls upon the other shareholder to buy out his shares, or in case of a put option, the put option holder requires the other shareholder to buy him out. Now, the validity of a put option has been questioned in the past when non-resident parties have been involved with respect to the return on their investment. However, the regulators have now further eased the exchange control regime governing options. The current position of law with respect to option clauses in shareholders agreement is lawful, and such contracts are not void as long as it's without any assured return. So the guiding principle over here is that the non-resident investor is not guaranteed any assured exit price at the time of making such investment or agreement, and shall exit at a fair price computed. Handing back to Harini, can you take us through an interesting case involving the validity of a put option clause?
Yeah, sure, Khusnuma. So I just wanted to also share, I think there are a lot of judgments around call and put options. And in fact, I think as transaction lawyers, Khusnuma would agree with me that we would have spent hours negotiating on how these clauses should be structured. But I think it would be good if we focus on this one particular case, that is the Tata Docomo case, also because the law around then was changing, and therefore we feel this would be one of the more interesting cases to point out here. So like Khusnuma pointed out, only when you have non-resident issues or factors in your transaction, the call and put options have been heavily analyzed. And this is because the RBI rules say that you cannot have a predetermined price for the sale of shares when it concerns a non-resident. So in the case of Tata Docomo, what had happened was Tata Sons Limited and Tata Teleservices Limited had executed a shareholders agreement with NTT Docomo, a Japanese company, in 2009. So under this agreement, there was this one clause which stipulated that if Tata Teleservices failed to satisfy certain performance indicators as was stipulated in that agreement, then Tata would be obliged to find a buyer or a set of buyers for Docomo's shares at either the higher of the fair value of the shares on a particular date or at 50% of the price at which Docomo purchased its shares. And so, business conditions were such that business wasn't going on well and Docomo wanted to exercise this option. The interesting portion is that in January 2014, around the time this was happening, the Reserve Bank of India had come out with norms which specified that foreign companies can only exit investments at a valuation based on return on equity. So this matter went to arbitration and then it went on to Delhi High Court where other facets were also explored. But the long and short of this case was that the arbitral tribunal held in favor of Docomo, awarding them damages finally. And it said that Tata wasn't constrained due to policy reasons because it also refused to find non-resident buyers for the shares of Docomo. And it was not the case that, policy was not in their favor. Khusnuma?
Thanks, Harini. The next clause that you would see is non-solicitation and non-compete. Now, in this clause, it will provide that the promoter shall, as long as the investor is a shareholder or till a reasonable period of time after he ceases to hold any shares, not solicit any employees or customers of the company. Similarly, when the parties may also provide a non-compete clause, wherein the promoter agrees not to compete in the same business or similar business of the company till the time the investor holds shares in the company or for such reasonable time after he ceases to hold any shares. Now, the enforceability of such non-compete clause is questionable in view of Section 27 of the Indian Contract Act. However, reasonable restrictions are therefore put in such clauses with respect to time or geographical location or limiting to a vertical line of business of the company so that the restriction looks plausible in the interest of the business and goodwill of the company and to protect investor value as well. Harini, is there any interesting case that you could share on this point as well?
Yeah, so I think we can all take cue from the picture that is available on the slide. I'm sure many of you recognize Zahir Khan, the cricketer, just in case those of you, for those who don't recognize him. So he had appointed this company called Percept for his endorsement. And in that agreement that they executed amongst themselves, they had this condition that stated that when that agreement would be terminated, Zahir had to compulsorily give Percept an opportunity to match any offer made to him by some other party in case he was looking at other options. So before the contract expired, Percept sent a draft proposal to extend the agreement with Zahir. But 10 days after Zahir received this, he replied stating that he didn't wish to renew this contract or extend the agreement. And he argued that this particular clause was one-sided and it was very unfair because it constituted a restraint of trade. And because this was void as per Section 27 of the Contract Act. So this actually went to the Supreme Court, and the Supreme Court actually held that the restrictive covenant under non-compete would not be enforceable beyond the contract period because of the existence of Section 27 of Indian Contract Act, which obviously talks about restraint of trade. And I just want to highlight here that the Supreme Court also clarified that this principle would extend to other agreements as well and not restricted to employment agreements alone or consultant agreements as in this case. But we should also contrast this particular holding versus this Affle Holdings case, which was pronounced in 2015, where actually there was a transfer of business along with goodwill. So here the Supreme Court held, pointed out actually to the exception that is there in section 27 of the Contract Act because of the nature of transaction. And as we all know, the exception to section 27 is goodwill. And therefore, there was no restrictions out here. Khusnuma, I think the next slide probably also shows us section 27.
So moving on, you will also see the clause of representation and warranties in a shareholders agreement. Now, any person that is investing in a company would insist on certain representations and warranties being made by the company and its promoters about the business status of the shares that are to be issued to or purchased by the investor, whether there is any encumbrance or pledge, the financial situation of the company, whether it is in compliance with the laws of any potential litigations and claims against the company, ownership of assets of the company, liabilities of the company, and so on. Each representation and warranty should be carefully reviewed and negotiated as required. There are also exceptions to such representations and warranties, which must be clearly captured. You will see that in a disclosure letter. You will also observe that promoters may make certain representations and warranties on best of their knowledge and belief basis. Now, usually these kind of reps and warranties, which run into pages, are covered in a share purchase agreement or a share subscription agreement. Thereafter, when a shareholders agreement is also entered into, you will typically see the reps and warranties being limited to authority and capacity of the parties to enter into the agreement, and that the parties entering into the shareholders agreement does not violate any law or any contract that they have previously entered into. Now, one needs to also be careful whilst drafting the reps and warranties to see that the parties are in a position to actually provide such a rep and warranty. Just to draw reference to the Tata Docomo case, which Harini just spoke on, in that case, the arbitral tribunal had examined the rep and warranty provided by Tata, as the parties knew the exchange control regulations and other considerations might prevent performance under a simple put option clause. So one has to be mindful of these things. Moving on to the next clause that you would see is on termination. Now, the agreement can either automatically terminate upon either of the shareholders ceasing to hold any shares. That's what a termination clause can provide. Or it can provide that the agreement can continue in force and effect until terminated in writing by the parties by mutual consent. Or it can terminate if there is a breach and the breach cannot be cured within a cure period, or terminate on occurrence of certain events such as bankruptcy, winding up, dissolution, etc. It depends upon how you want to tailor or draft your termination clause. The next clause that you would see in a shareholders agreement is fall away of rights. Now, a fall away of rights clause will provide whereby preemptive rights or a right of first refusal right, a right of first offer, anti-dilution rights, they fall away once the investor ceases to hold a certain percentage of shares in the company, example 5% or 2%. So some shareholders agreement do cover this clause of fall away of rights as well. The next clause that you see is an important clause as well, which is governing law and dispute resolution. Now, the parties need to give a thought as to the governing law and dispute resolution process they would want to follow in case of any dispute or conflict which is arising from the shareholders agreement. Depending if there is a non-resident party to the shareholders agreement, the governing law and arbitration seat and place is negotiated by the parties. Now, there are certain points which we should keep in mind whilst drafting the dispute resolution clause, especially which involve the seat of arbitration. Harini will be highlighting these points.
Thank you, Khusnuma. So I think first it's important to understand the distinction between seat and venue. Uh, the venue refers to physical location, and whereas the seat refers to the governing law of the agreement. So, the Arbitration Act provides important provisions in Part 1 and Part 2. Part 1 actually applies to arbitrations when the place of arbitration is in India, and Part 2 applies to those arbitrations where place of arbitrations is outside India. So part one, covers typically arbitrability of disputes, non-intervention by courts, composition of arbitral tribunal, jurisdiction of arbitral award, conduct of arbitration proceedings, recourse against arbitral awards, and enforcement. Part two, on the other hand, that is restricted to enforcement of foreign awards governed by New York and Geneva Conventions. The 96 Act actually had lacunas which the courts have been trying to bridge. So the landmark judgment when we talk about seat and venue always have been the Bhatia International case and the Balco case, which I'm sure many of you would have come across. So in Bhatia International versus bulk trading that was pronounced by the Supreme Court in 2002, that case held, the Supreme Court held in that case that the provisions of Part 1 of the Act would also apply to international commercial arbitrations seated outside India unless the parties had expressly or impliedly agreed to exclude its application. So because of this judgment, the Supreme Court in a later judgment, Venture Global Engineering versus Satyam Computer Services in 2008, it interfered in the foreign seated arbitration and held that Part 1 of the Act applied to such an award, and hence courts in India would have jurisdiction to set aside the award. So now these judgments led to a lot of international commercial arbitrations being severely affected, and foreign parties showed disinclination towards engaging with in businesses with Indian parties. Then came the Balco judgment in 2012, Bharat Aluminium Co. versus Kaiser Aluminium Technical Services, where the Supreme Court held that Part 1 of the Act does not apply to Part 2 of the Act, and the courts in India could not entertain interim applications under Section 9 of the Act in foreign seated arbitrations, which was governed by Part 2 of the Act. And the court also held that the judgment would apply prospectively to arbitration agreements, which means it would kickstart from September 6, 2012. Now, this prospective application obviously led to a chaotic situation where the Bhatia judgment was applicable in certain cases and the Balco judgment was applicable in some other cases. And then pursuant to this Balco decision, of course, Indian courts had no jurisdiction to intervene in arbitrations which were seated outside India, and Part 1 was not applicable. So the parties to a foreign seated arbitration were blocked out of Indian courts in seeking interim relief. And to remedy this situation, the 96 Act was amended. Now, the 2015 amendment, it resulted in amendments to sections 9, 27, portions of section 37 of Part 1 of the Act, and that became applicable to foreign seated arbitrations unless there was an agreement which existed to the contrary. So section 9 was amended to state that once the arbitral tribunal is constituted, the court shall not entertain an application unless circumstances demand it so, thereby minimizing the intervention of courts. But despite these amendments, confusion stayed on. And if you see, as recent as March 2020, the Supreme Court has opined on the seat versus venue debate. This was in the matter of Mankastu Impex Private Limited versus Air Visual Limited, where it reinforced this whole seat of arbitration versus venue of arbitration. And it said it cannot be used interchangeably. So it said that the mere expression place of arbitration cannot be the basis to determine the intention of the parties as to governing law. So the seat should be determined from other clauses in the agreement and the conduct of the parties. And the court also held that if the arbitration agreement is found to have a seat of arbitration outside India, then Indian courts cannot exercise supervisory jurisdiction over the award or pass interim orders. So the essence, therefore, is this. I think the law around seat versus venue has been fairly clear. So it's important that when you are drafting, you need to clearly emphasize on what is the seat and what is the governing law. The venue.
Thanks, Harini, for that. We now move on to the last clauses, that is the miscellaneous provision clauses that will appear in a shareholders agreement. So in this, you will typically see your notice clause, confidentiality, severability, counterparts, entire agreement, waiver, amendment, stamp duty. Just to go through a few of them, in the notice clause, this clause will cover how notices, demands, or communication is to be made or given under the agreement. The delivery process is also covered, whether it will be by hand delivery, international courier service, or email, or sometimes it can also provide by email, which is followed by a courier delivery. The parties, while sending the notices or any communication, must adhere to what is specifically provided in the notice clause, because otherwise the other party can raise an issue that the delivery of notice was not as per the terms that were agreed. The other clause is confidentiality. In this, you will see that it covers that all information of confidential nature which has been disclosed needs to be kept confidential and not to be disclosed to anyone without the prior written consent of the other party. However, you can provide exceptions to such confidentiality clause as well, which would include if there is any disclosure which is approved by the other party, or if there is any information which is already in the public domain, which is through no fault of the receiving party, or where the disclosure is required under any applicable law or by a regulatory authority, or where the disclosure is reasonably necessary for the relevant party's professional advisors, legal or financial advisors, and who shall keep that information strictly confidential as well. You will also see clauses of modification or amendment. Now, this clause will provide that the agreement may be modified or amended only in writing, making specific reference to this shareholders agreement duly executed on behalf of the parties. You will also see severability clause, where the clause will provide that any provision of the agreement which is invalid or unenforceable shall be ineffective to the extent of such invalidity or unenforceability only, without affecting in any way the enforceability or validity of the remaining provisions of the shareholders agreement, and which shall remain in full force and effect to the maximum extent permitted by law, and that the party shall endeavor to replace such invalid and unenforceable provisions with such other valid and enforceable provisions without deviating from the fundamental understanding that is there between them. Cost and expenses will also be another miscellaneous provision clause, which will cover how each party shall bear the cost and expense in preparation of the SHA or the stamp duty and any incidental expenses relating to the same. So these are the boilerplate clauses that you typically see. But one thing to remember is that you will need to tailor them as well as per the specifics of your transaction and the commercials that are agreed between the parties. I just want to give one example over here of a simple notice clause as to why you need to be sure as to not just take a notice clause blindly and put it in a shareholders agreement because it's a boilerplate clause, but be mindful, because you will see that many a times notice clause will mention that the notice can be communicated by email, courier, or even fax. But you must first check with the party that do they even have a fax line, because when it comes to actually sending out the communication, these issues will crop up and you will be unable to send the fax. So then you'll have to amend the notice clause by saying that this will not be one way of delivery. So this brings us to the end of the presentation. Just tried covering all the main clauses. Harini, do you have anything else to add?
Yeah, I think I just add that, this example that you've given of notices, I think in post-COVID scenario especially, where there have been a lot of cut-paste incidents, in fact, The notices clause doesn't include, email as a form of notice. So I think in a lot of our matters, we're seeing that there is an inherent issue here where that's not being accepted as a mode of communication. So I think we should be mindful of the situation also we are in when you're drafting your SHAs. I think that's it from me. Khusnuma, if you'd like to add anything.
So that's really very interesting point. And yes, one should be mindful of how they are drafting it. So thank you for that. And that brings us to the end of our presentation. Thank you for your patient hearing.
In an event, in the event an SHA is signed between parties, however, the company does not amend its articles of association to give effect to the terms of the SHA, is it the duty of the company which the company has failed to perform? How does one deal with this situation? I think basically it means that what the person is trying to convey is there is a difference between the SHA and the AOA.
Yeah, so I think I'd like to just contribute here, and I think Khusnuma can clarify this as well. See, typically how it goes is that when you are drafting an SHA, especially when there are private equity players involved, you also, through the transaction, you also ask for an amendment to the Articles of Association as part of that process itself. And one of the closing conditions to these transactions is that the amendment to the articles takes place and it's uploaded in the ROC, and a copy of that is given to all the parties. So that's how, say, an investor ensures that the provisions of the shareholders agreements are enshrined in the articles of association. So since you normally add it as a closing condition, you don't then face issues. You try to work around this. I hope that answers the question. Khusnuma, if you'd like to weigh in as well.
So basically, yes, in case if the shareholders agreement will usually also cover a clause which says that the certain provisions will be entrenched into the articles, and the company should try and entrench these clauses into the articles so that in case of any inconsistency, there is not any issue. So, and then of course, you will be registering the same with the updating your articles with the ROC. So yes, I am agreeing with what even Harini has mentioned, that one should see to it that whatever the provisions are there, the company should take cognizance of the same and see that the clause in the shareholders agreement does get entrenched into the articles of association.
Okay, great. Next question. What role does an SHA play in PE transactions? If possible, could you explain in the context of a PE in a startup stage?
So I think here, maybe, startup and PE is not often seen in the same context. When you talk about startup, it's more angel funding, which is typically friends and family, or it's VC. When you say PE, then that is in itself a different league. But primarily, it still boils down to the same fact which we just explained. And in that, the SHA clauses are, of course, battle between the parties, and then it's transposed on the AOA. Khusnuma, would you like to add to this?
No, so I think you have covered it basically. And yes, in a PE, even if there is an investment, a PE transaction which is happening, as we have seen and covered, there will be your restriction on transfer rights, your anti-dilution rights, etc., that you will try and cover even in the shareholders agreement where a private equity investor is coming into picture.
The next question is, can there be a clause on buyback of equity shares in shareholders agreement and then be enforceable by making the shareholders give offer for buyback their equity in a private limited company?
So you do have buyback clauses as well as far as an exit clause is concerned. Usually you tell the promoters to buy back these shares. As far as giving an offer is concerned, basically you will have to even take cognizance of the fact that there is the Companies Act, which has its own buyback regulations and provisions, which only allows 25%. But I'm not sure. Could we just go back to that question, please? I think the question just.
Sure. Can there be a clause on buyback of equity shares in shareholders agreement and then be enforceable by making the shareholders give offer for buyback their equity shares in a private limited company?
Yeah, so as I said, that in case it depends upon how your clause has been drafted, you can say that the promoters will have to buy back these shares from them for providing an exit to the investor or to the other shareholder that has come into it. So your clause can provide for that.
Great. There's one clause, there's one question relating to the pandemic. Will material adverse effect clause get triggered in this pandemic?
So I think this deserves a very lengthy discussion. And right after the pandemic, there have been a lot of webinars that have been focusing on this. How the MAC clauses are going to impact. So I think this should be reserved for another discussion as a whole.
What is the specific difference between a rights issue and a ROFO?
Now, it is both are different terms. The right of first offer is basically, as I mentioned, that when in your kind of your restrictions of transfer rights, your right of first offer is when the holder of the right of first offer is approached to get these shares. A rights issue is basically when you are actually wanting to raise, when you are wanting to give further issuance of shares. So that is covered under a different section of the Companies Act. And your right of first offer is actually one of your transfer restrictions where you will actually be able to, the promoter will be giving a price with which to begin the negotiations with, and investors will usually, when seeking an exit, they will prefer that the promoters have a right of first offer. A rights issue is very different, where you're actually going to issue new shares to the existing shareholders of the company, as per the provisions which are there enshrined in the Companies Act.